So I'm Lorna Johnson. I'm the Executive Director. I've been in post for almost 10 years now, which is a little bit scary. But anyway, and this is my colleague, Richard Wilson, who's our case manager. So just moving on, please, Brian. Sorry, Brian's moving my slides on for me. Yeah, there we go. Yeah, so I thought I would just start by just giving a quick reminder about when the Councillors' Code of Conduct applies. So just to be clear, it doesn't apply to your private or family life. It applies when you're acting as a councillor, when you've referred to yourself as a councillor, and or when you could objectively be considered to be acting as a councillor. And that objectively considered to be acting as a councillor, if we're looking at that, the Standards Commission will always consider whether members of the public with knowledge of the relevant facts would reasonably consider that you were acting as a councillor at the time of the events in question. And I think that really applies to what we're talking about today, the confidentiality, particularly in respect of when you're using social media. Because I think generally your profile as a local politician, as a local authority member, will generally mean that members of the public might automatically assume you're commenting in your role as a councillor in anything that you post, publish, or share online. And that's particularly the case if you are discussing matters that relate to the council. If you've identified yourself as a councillor on your social media page, in your biography or anything like that, or your conduct could be regarded as bringing your position or the council into disrepute. So the reason that I'm mentioning all this is because it does tend to be the case with breaches of confidentiality. It is quite often councillors disclosing information on social media that is still confidential. So that was just a reminder that the code probably will apply if you're posting something on social media. So just moving on, if that's okay, Brian. Yeah, so just a few principles to begin with in terms of confidentiality. And the first thing is that you have a right of access to council information. And I think that's really important for your scrutiny role and your strategic setting role. So if you don't feel that you're getting information, you really need to raise that with senior. If you don't feel you're getting sufficient information or at the right level, that's something that you need to raise with senior council officers, because obviously you do have that right. So it's both a statutory right and a common law right. So under statute, under the Local Government Scotland Act 1973, and the Freedom of Information Scotland Act 2002, you have a right to information. So you have a statutory right to inspect any council document which contains material relating to any business which is to be transacted or discussed at the council committee or any subcommittee meetings. And that applies irrespective of whether you are a member of the committee or subcommittee in question. And it extends not just to the reports that are being considered, but also to any other relevant papers that are perhaps backing up that report. There are exemptions to that. I'm sure everyone's aware of these, but that right does not apply to exempt information, and that's information that is likely to be considered in private at the committee or subcommittee meeting. And that could be information that maybe relates to council employees, applications for grant and other services, care of children, contract and industrial negotiations, and also legal advice, both internal and external legal advice, maybe information about criminal investigations as well. You also do have a common law right, and that's a much broader right to information, and that's based on the principle that on the face of it, you have a right to inspect council documents as far as that access to the document is reasonably necessary to help you perform your duties as a member of the council. So that's commonly referred to as the need to know principle. So in other words, you are entitled to view and inspect copies of all documentation held by the council, provided you can show you have a need to know that, and that you have no ulterior or improper motive. So it's not a kind of roving commission right to go and look at anything that you want to. So just been curious about something is not sufficient. You really do need to be able to demonstrate that you have a need to know to perform your duties as a councillor. So if you're ever questioned about that, if you're ever asking for a document and someone is maybe pushing back on it, then it might be helpful for you to think about why you need to know, why you want to see that document, and to be able to explain it. It's because I want to be able to scrutinise this, or it's because I can't look at the overall strategy, without this information. Another thing to bear in mind is, although councillors are not in their own right individuals that are subject to the Freedom of Information Scotland Act, you should be aware that any information that you produce or receive could be subject to disclosure, as that the 2002 Act provides individuals with the right to request information held by the council. So that could include information that you've produced yourself in an email, or that you've received, something like that as well. So just bear that in mind. The Standards Commission has produced a joint advice note with the Improvement Service on the right of access to information, and it can be found on our website, and that covers a lot more of this, or it covers that information that I've just discussed. So why is it legitimate for the council to keep some information and documents confidential? Well, there's several reasons. But amongst other, the kind of main reasons are it allows for full and frank, unimpeded discussion to feed into decision making. It ensures proper communications and procedures are put in place to support any decision. So, for example, it gives council officers the chance to prepare public information before that information is released into the public domain, and maybe leaflets or whatever. It gives the opportunity for officers to be briefed, and also for any partner bodies to be briefed. It could be that that the information has been kept confidential to retain a commercial advantage or avoid a disadvantage for the council, and also potentially to avoid speculation or causing unnecessary alarm or upset. And I'll talk about that a bit more when we go on to talk about some actual cases that we've had before us. So given the potential damage that it can cause in terms of unnecessary alarm or upset, or just causing additional work for unnecessary work for council officers, it is really important that you respect the confidentiality provisions in the code. Okay, so Brian, if I can move on, and I'll just cover those. Yeah, so the confidentiality provisions are paragraphs 3.21 to 3.23. 3.21 says, I will not disclose confidential information or information which should reasonably be regarded as being of confidential or private nature without the express consent of the person or body who is authorised to give such consent, or unless I'm required to do so by law. I note that if I cannot obtain such express consent, I will assume it's not given. So the important thing there is to always think about who would be the author, who would be the person that would be able to give that consent for you to disclose that information. So obviously it's not good enough to just turn around to the councillor sitting next to you and saying, is it all right for me to disclose this on social media the minute this meeting is over? They're not likely to be the person who's got the authority to give that consent. It's much more likely to be the author of the report, or potentially the chief executive or a senior officer. Okay, so Brian, moving on to the next one. So paragraph 3.22 of the code says that I accept confidential information can include discussions, documents, information which is not yet public or never intended to be public, and information deemed confidential by statute. And I'll cover what is public in a little bit. Paragraph 3.23 makes it clear that you can only use confidential information to undertake your duties as a councillor, and that you must not use it in any way for personal or party political advantage or to discredit your council. And that's even if you hold the personal view that the information should be publicly available. The code does mention party political advantage, but we interpret that as being just political advantage, full stop, because obviously there are some councillors who are not party affiliated. So the code makes it clear that confidential information is not just information that is deemed to be confidential by statute. It can include discussions, documents, and information which is not yet public or never intended to be public. So sometimes confidentiality is just a matter of timing, in that the information may be released into the public domain a day later, a month later, whatever, at a slightly later stage. But the code makes it clear that you must respect the requirement for confidentiality, like I said, even if you think it should be released at an earlier stage. So in terms of, well, what is already in the public domain? Is this information I've been given, is it already in the public domain or is it not? We would look really to see whether it was easily, readily, and realistically accessible to the public. So the fact that one member of the public may know the information would not mean that it's no longer confidential. It would really need to be information for it to no longer be confidential. It would really need to be something that was easily, readily, and realistically accessible to the public at large. Our guidance on the code says you should always seek advice if you're in any doubt about whether any documents, information, or advice is confidential, and that's particularly if you're intending to disclose the contents to any outside body or individual, and again, if you're intending to post something about it on social media. So potentially disclosing information to another councillor could be a breach of confidentiality. The code doesn't restrict a possible breach to disclosures just to people outside the council, such as members of the public or press. It could potentially be even to another councillor if, for example, you had been given that information in your capacity as a member of a certain committee or a certain group or working group or something like that. Okay, so just moving on. So just to give some examples of what information is confidential, I think everybody will be quite familiar with information that's explicitly marked as confidential, but information can be confidential if it's given to you in other ways as well, and if it's implicit from its very nature. But to cover that first one, so information that might be explicit might be because, like I said, it's been marked as confidential. It may be that a council officer or a member of the public has asked you to treat it as confidential. It could be that it's exempt information under the Local Government Act, and that's, I think, most councils seem to call it the pink papers. So that might be printed on pink paper. It might be quite obvious that it's confidential. And it could be information, personal information which would be covered by GDPR, and that releasing somebody's information about, I don't know, constituents' health or something like that might well be a breach of that. So it doesn't always need to be explicit. Confidential information can also be implicit. So just from the very nature of the information, it should be clear to you, or even the circumstances in which it was provided, it should be clear to you that it's confidential. So that could include commercial information, and such as information relating to a contract that the council is awarding or has in place, or with a contractor's business. It could be personal or sensitive information, such as information relating to an employee's, a council officer's employment or health. It could be information that's confidential, as I discussed, as a result of statutory provision. Information that's discussed in a closed or private section of a meeting that should probably put you on notice that it's likely to be confidential. Legal advice, and that could be either legal advice provided by external legal advisors or even council officers. And that really will be covered by legal privilege and shouldn't be disclosed without permission. Potentially information received as a result of a relationship where there's an expectation of confidence. So that could be, for example, between you and a constituent. And also information about any ongoing investigation being undertaken by the Ethical Standards Commissioner. By the time it gets to the Standards Commission, we hold our hearings in public, so there's not a similar expectation of confidentiality at the time a complaint reaches the Standards Commission, but the Ethical Standards Commissioner does undertake his investigations, that they are confidential when he's undertaking the investigations. Okay, so moving on. Okay, so this, I think, David, we were going to discuss the scenarios at this point. The first one was a councillor who disclosed information about the number of extra graves the council was intending to dig during the coronavirus pandemic. He'd been in a meeting where that information was discussed, came straight out and put it on social media. And the panel in that case, I don't think the panel necessarily felt that the councillor had disclosed that information for any kind of party political reason or anything like that. I think the panel accepted that he was just trying to be open and transparent with his constituents. But the reason it was a breach of the code was obviously it was confidential information. It was information that was going to be made public, but not at that time. Council officers wanted more time to prepare communications about it. And by disclosing that information, he really opened council officers up to phone calls from journalists, to phone calls from worried members of the public. So really creating extra work. And as David said, it then really kind of erodes that trust between officers and councillors. I think in that situation, you'd be very reluctant to give that councillor any more information of a sensitive nature about the response to the pandemic, the proposed response. So that one was a breach of the code. The next one was also a social media one, where a councillor posted information about, I think it was a list of leisure facilities that the council was considering closing as part of kind of budget saving, as part of its trying to save money. And again, that one was when I talked about before about sometimes information is kept confidential to allow for full and frank discussions. And obviously by disclosing information in that way, the public can put pressure to bear on you, and the media can put pressure to bear on you. So that one, I think, was an example of how that could then affect proper and full discussion and decision making. That one was also quite an interesting one because the information that had actually been shared between the political group. And so I think, Richard might correct me if I've got this wrong, but I think at the hearing there was maybe a slight argument. Well, it was already, everybody in the political group knew about it, but that did not mean that information was in the public domain. And so it was still considered to be confidential at the time of disclosure. Are you nodding, Richard?
Yes, yeah.
Good, okay. Just checking. Good. And then the last case that we've got there is where a councillor advised a journalist of a proposal to change the use of a care home, in his word, to an asylum facility. And again, that was information that was confidential at the time. And I think that maybe ties both of these previous two cases together. It caused difficulties in terms of both inquiries to council officers when notice, and also in terms of the actual decision hadn't been made at that stage. So the council's then scrambling around trying to respond to this actually they weren't, because I don't think the journalist actually then published information about it, but potentially they could have been scrambling around trying to respond to this, and it could potentially have affected the decision making as well. So that one was also a breach of the code. So I think, Richard, you're now going to talk about, I'm sure you've all heard about the right to freedom of expression. So Richard's just going to talk about how that potentially has an impact or doesn't have an impact in terms of confidentiality as well.
Afternoon, everyone. I'm Richard Wilson. I'm the Standards Commission's case manager. A few slides here just to look at one or two other aspects that arise in relation to confidentiality. So, as Lorna said, you're probably familiar with the right to freedom of expression, which is given to everyone by Article 10 of the European Convention on Human Rights. You're usually talking about it when you're thinking about things that councillors say in meetings or say on social media, but it also applies to the disclosure of information. It's a qualified right, and that means that it might be limited by a restriction. And an example of a restriction would be a sanction that might be imposed on you at a hearing if you're found to have breached the code of conduct. And those restrictions need to be necessary and proportionate, and they must be for a legitimate aim. And we've got there in the slide some of the legitimate aims, what those can be. It can be to allow officers to perform their duties. It can be to allow the council to function effectively, or, as Lorna touched upon in a couple of the case examples, to avoid unnecessary concern amongst the public. And one of the aspects that the hearing panel will look at when determining when a restriction might be legitimate would be considering whether there were other opportunities for the councillor in question to have achieved their objective other than by disclosing the information that was confidential. In some of the cases that we mentioned on the previous slide, the panel found that the restriction could be justified, and that was a need to preserve confidentiality until any final decision has been made at the council level. And that means that it enables officers to perform their duties to avoid unnecessary concern. And the panel also considered that the requirement to keep the information confidential was necessary to protect the bond of trust and confidence that exists between councillors and council officers that enables local government to function effectively. I've got a little point there on the slide that public interest can sometimes be so strong as to override the duty to keep or maintain confidence, but that's unlikely to apply if it's only a matter of timing we're talking about, and if there are good reasons why the information was to be kept confidential at the time. Next slide, please, Brian. Other aspects of the code also play into confidentiality matters. Councillors are obliged to be respectful and courteous to everybody at all times, and that includes sharing information, whether confidential or not. When councillors are appointed or nominated to outside bodies, they're also obliged to adhere to the code when they're attending meetings of arm's length external organisations or ALIOs. You could also fall foul of the duty to use council resources. You're not the code states that you can't use council resources imprudently. That means without thinking about the implication or consequences, unlawfully, or for any party political or campaigning activities or matters relating to these. You should also bear in mind Section 7 of the code, which relates to taking decisions on quasi-judicial or regulatory applications, and ensure that you're not posting anything or talking about anything that could perceive to be demonstrative of bias, unfairness, or prejudging in relation to any quasi-judicial or regulatory applications, i.e. licensing or planning decisions that you might take, or any that might be subject to an appeal. Councillors should also avoid making any public comments that could bring their council into disrepute. And just noting there that paragraphs 24 and 25 of Annex A of the Code, and Annex A of the Code is the one that deals with relations between councillors and council employees. That doesn't seek to restrict your ability to properly scrutinise the performance of the council or the council employees, but it seeks to discourage you from making any unfounded public accusations either about any employee or the council as an entity. Next slide, please, Brian. One or two other factors to consider. We've already touched on the right to good quality and relevant information. You've got the right to receive that from officers in order to make decisions and undertake your scrutiny role. The information should be proportionate, balanced, comprehensive, and understandable. And if you don't consider that you understand or are receiving the information that you require to be able to make decisions and carry out your role, you should raise that with the appropriate senior officer, such as the relevant head of service. How you're requesting information, that ties in with courtesy and respect towards officers. You should always consider what you're expressing and the way you're expressing it when you're asking officers for information. You should be mindful of the way your conduct may be perceived, and you should be able to seek any information that you require in a constructive, respectful, and appropriate manner without resorting to any personal attacks or being offensive or abusive. Seeking to take unfair advantage, the code states that councillors and employees should work in an atmosphere of mutual trust and respect, with neither party seeking to take unfair advantage of their position or influence. So you should remember that you have, or you might be perceived as having, a position of power over officers. and you shouldn't take advantage of your position and your potential influence as a councillor to seek information from officers that you're not entitled to. And that's particularly the case with junior employees, junior officers who may not be used to dealing directly with councillors. You should remember that you do have that inherent position of power, and that means officers may feel pressured into taking a particular action or making a decision, or to focus on a matter that you're concerned with and prioritise it over other work, even if they've got tasks that should be completed first. You should therefore refrain from making any unreasonable demands or demanding that information be produced in an unrealistic time frame, for example. And you should be aware that making persistent demands for information can be disruptive and can prevent officers from undertaking their roles effectively. Inappropriate involvement in operational matters also comes into play. The code requires you to refrain from that because operational matters are the responsibility of officers. If you become inappropriately involved in operational management or operational decision making, that is likely to be a breach of the code, and it can damage your relationship with officers and have a detrimental effect on how officers perform their duties. So as such, you shouldn't be seeking information for the purpose of becoming involved in or directing decisions on matters that are operational in nature. Next slide, please, Brian. So I realise we've gone over quite a lot today. On our website, you can find lots of information and advice. We have our main guidance document on the code, which contains case examples and illustrations. And then we also have a suite of advice notes that we've published on various different topics. We've got a list of them there. Strategic versus operational is a popular one and often considered, and we've heard that councillors find that useful. We've also got some short guides for members of the public, a guide to the code for members of the public, one about assisting constituents that you should feel free to hand to your constituents so they can understand what you can assist them with and what you can and cannot do for them, and also one about attending community councils, which again people have found quite useful. Next slide, please, Brian. So on our website, you can also find decisions from our previous hearings, our no action decisions where Standards Commission members have decided not to hold a hearing. You can find links to the codes of conduct, our guidance and advice notes, as I mentioned, and also our quarterly standards updates that you probably receive from your council monitoring officers. You can follow us on LinkedIn, and our email at the end there, inquiries@standardscommission.org.uk. Feel free to get in touch with us if you want to ask any questions about the code or how it should be interpreted. Lorna, do you want to?
Yeah. Thank you. Yeah. So like Richard said, please do get in touch with us if you're not sure about anything to do with the code, and we'd rather you sought advice and we talked through an issue. It would be me or Richard that would answer a query, and we're quite happy to kind of talk through a scenario or an issue with you if you've got any questions, and to try and make sure that you are complying with the code. I think, Richard, in the previous slide you were talking about the advice notes. We've also just revised our advice note on gifts and hospitality as well, and put in some examples, much more examples in that advice note. So that one's just been updated.